Absolutely. Under Indiana law, you don't have to have an operating agreement if you're a single member entity. However, you need an operating agreement. An operating agreement does a lot of benefits for you. It strictly allows you to decide who owns what, who's in charge of what, and what percentage interest people have, what their roles are, and how the company operates. If you don't have one, you're going to default to the Indiana statutory rules, which one are subject to change. But also, let's say one of you is an investor and one of you is not. Well, if you don't have an operating agreement, the law is going to treat you as equal owners of that entity rather than a mix of what maybe some have a majority interest versus a minority interest. So an operating agreement is going to tell you all that. And it's going to really lay out how the business is owned, how it's operated, and how it's managed. Now, the other thing that's very, very important for it is for estate planning purposes, we can utilize it for different tax treatment for different interests. We can utilize it for different gifting purposes for how that business interest is transitioned to heirs or to others that you want to go to without having to deal with that outside of the entity. We can also make sure that if we want to put that in trust, we have those provisions included within the operating agreement that allow that to happen for estate planning purposes. The last thing is it really helps with disputes because it sets out how the business is expected to run from the get-go rather than dealing with the dispute when it comes up and saying, oh, I wish we had something that told us what to do. This document is laid out, and through our experience, having dealt with problems, is laid out to handle all of those issues, or at least be able to address on the high level of how to address each of one of those disputes.